Welcome to JPAL's IDEA Handbook webinar series. I'm Sean Cole. I'm on the faculty at Harvard Business School, and I'm the co-chair of JPAL's IDEA initiative. These webinars accompany the release of a handbook on using administrative data for research and evidence-based policy funded by the Alfred P. Sloan Foundation. The handbook provides a series of technical guides and case studies on how to make administrative data more accessible for research and policy. Today, it's my pleasure to introduce Kathleen Murphy. Kathleen is a certified IRB professional, recently retired from Northwestern University, where she served as a board member, vice chair, and manager of the Social and Behavioral IRB, as well as serving on numerous IRBs over the past years. She'll be presenting her chapter titled Collaborating with the Institutional Review Board. This chapter is about what the IRB does and does not do, and what researchers, data providers, and related stakeholders can expect from IRB review of research that involves humans. In the context of our handbook, the chapter focuses on research that accesses and uses administrative data. The goal of the chapter in the handbook is to provide researchers, data providers, stewards, and other stakeholders with the tools they need to understand the IRB process. IRB review is a key step in launching research projects, and learning about the IRB perspective will help researchers and policymakers understand how to successfully navigate this process. Today, Kathleen will discuss what IRB is and what it does, how the IRB relates to international research, how IRB protects participants in research projects, and strategies for communicating with the IRB. With that, I would like to invite you to view Catherine's talk. Following the talk, we'll reconvene for a live Q&A session.
Thank you for that introduction. Before I get started, I want to thank JPAL for pursuing this initiative and for the team of editors who have worked tirelessly to make this important contribution to the use of administrative data in use research happen. It's truly a service to researchers, data providers, and a number of other stakeholders in the research enterprise, and so I want to thank you for the opportunity to contribute. Now, as was said in the introduction, I'm Kathleen Murphy. Among other things, I am a certified IRB professional, but I started my substantive adult life as a social scientist. I spent years serving on research projects and in advising doctoral students on their research. Then after I transitioned from clinical practice, I worked for a period of time as a social science data librarian, where it was my job to purchase access to data repositories and data files that students and faculty could use. Throughout my different professional careers, I have served in various roles on different IRBs. All this by way of saying I have been on many sides of the data collection and the data sharing experience. I know that any discussion of the use of data in research is multifaceted, and I also know that the relationship of the researcher to the IRB is not always an easy one. Nonetheless, we all play a role in the knowledge building process, and to do that, we need to work together to understand how to think about and communicate about the risks and benefits of research as a greater good and not just a response to some rules. So what I want to accomplish in this presentation is to go over what the IRB is and what it does, to look at some special contexts to think about, including international research and institutional policies, how the IRB protects participants, and then some strategies for how to collaborate with the IRB. So what is the IRB and what does it do? The Institutional Review Board in the United States is an administrative body that reviews human research as defined by the federal regulations, which are formally known as the Common Rule, or Subpart A, to 45 CFR 46, which essentially states that an IRB exists to ensure the ethical protection of participants from the reasonably foreseeable risks of harm caused by research. Now, the Code of Federal Regulations for the Protection of Participants in Research was published in the mid-1990s and is the codification of the ethical principles of the Belmont Report, which was released in 1978 and published in 1979. Now, there are equivalent ethics review processes in other countries, often referred to as ethics review or research review boards. Whatever they're called, the harms to a participant that an IRB or an ethics review board considers are consistent across countries and include physical, psychological, social, legal, and economic risks, as well as community or group harms. An IRB, or an ethics review process, may be part of an academic institution, a medical facility, a federal, state, or local agency, or any other organization or commercial entity that chooses to conduct human research. An IRB reviews human research, and while all research uses information or data in various formats, for the purpose of this talk and for the chapter that I contributed to this handbook, the focus is on research that accesses and uses administrative data in different forms, formats, and contexts. This may include research activity where administrative data are the central feature of a study, or where the data are part of a larger project. There may be different contexts, such as international research or multi-site or collaborative research. Some data-driven projects will include only existing administrative data, while others will include retrospective and prospective data, alone or in conjunction with other research methods. Some projects only involve the analysis of data, while others can include multiple iterations of interventions. IRB review always takes all of these design factors into consideration in the context of a well-established ethical and regulatory review process. Now, the singular mission of the IRB is the protection of participants in research. There's a federal definition of what constitutes research activity that requires IRB oversight. I'll talk about that definition in a minute, but what people need to know is that there is this singular focus of the IRB, and all of the ethical principles and regulatory requirements are related to protection of participants and their identifying information. To that end, IRB review can be boiled down to three basic focal points of interest: the identifiability of data or information that's being used or collected in the research, the sensitivity of those data as it relates to the identifiability of the data, and finally, the probability and magnitude of harm as it relates to the sensitivity of the data. Now, as you read the chapter and as I continue with this overview, these themes are highlighted because they are at the core of what the IRB does and how it considers the ethical conduct of research activity that is under its purview. In that regard, a side note about international or global research. Human research can take place anywhere in the world, and there are over 1,000 laws, regulations, and guidelines on human research protections in the 133 countries that have some ethics review process. The Office of Human Research Protections, under the auspices of the Department of Health and Human Services here in the United States, annually compiles the most relevant regulations and agencies that regulate research in each country. The citation is in the chapter, and with even a cursory look at the compilation, you will notice that some, though not all, countries that have ethics review process have guidance regarding social and behavioral research activities. Countries that do have such guidance tend to have more restrictive data protection rules and regulations than those that we have in the United States. And so knowing the country and the local regulations that apply is important when you start thinking about research, and certainly when you submit it to the IRB. That said, in addition to the country regulations, generally what the IRB is looking at with research that takes place in other countries is guided by some basic principles, which I just want to go over right now. International research is not effectively different from domestic research in terms of the ethical principles of respect for persons and beneficence and justice as are articulated in the Belmont Report. Cultural norms, however, will always be the focus of attention, and respect for culture needs to come across in the research proposal. Research in another country may involve observing or recording activity that, while legal in that country, might be illegal or unethical in the United States. Child labor, unsafe working environments, differential treatment of men and women in the workforce, and a number of similar activities that are illegal in the U.S. may be part of research in another country, or the reverse. Activities that are legal in the United States but illegal in another country sexual orientation being the quintessential social behavior that may be illegal in a number of places, so that even asking the question about orientation can place a participant at risk of imprisonment. IRBs will always work with researchers on how to protect participants in research in the social, ethnic, and cultural context that the research is taking place in. And that includes when observing or recording illegal activity in particular. Now, what constitutes a vulnerable population sometimes may be more broadly defined in international research to include, for example, issues of language and literacy and other locally defined considerations. And then finally, there's the concept of equivalent protections, which is an OHRP concept that encompasses the expectation of protection that is equivalent to what would be here in the United States. For example, even though HIPAA is a US regulation, similar protections will be afforded to medical records in other countries when research is involving medical records, even when that's not the local standard. Okay, before getting into how the IRB protects participants in research, I want to talk briefly about what the IRB does not do. The IRB does not manage or approve or monitor grants or mechanisms for funding of research. That's typically handled in an office of sponsored research or a grants office of some sort. The IRB does not develop financial conflict of interest disclosures or management plans. That is typically handled by whatever institutional unit handles conflict of interest. The IRB does not initiate or put together data sharing agreements, such as a data transfer agreement or a data use agreement, or even non-disclosure agreements. As you heard more in depth last week, these are often handled by through some variation of the Office of General Counsel or the equivalent unit wherever a legal review happens in an organization. The IRB does not determine compliance with the Family Education Rights and Privacy Act, which protects education information. There is a FERPA officer at the point of the data source who will make any decisions about whether information is FERPA protected or falls under one of the exceptions to FERPA. And then finally, HIPAA compliance may or may not be part of IRB oversight or IRB responsibility, depending on who is the privacy board for the covered entity. Some covered entities do use their IRB as the privacy board, some do not. So it just depends on the institutional policy. Now, IRB professionals are knowledgeable about all of these contingencies that have to be considered with any given research project, and will work with researchers and data providers to make sure that all the bases are covered. In addition, the IRB may serve as the first line of defense when something is not consistent with the originally approved plan. Now I want to transition to the process that an IRB goes through to protect participants in research. There's a lot of detail in the chapter that I'm just going to briefly summarize for the purpose of this presentation. But again, all of this is guided by those three focal points that I mentioned earlier. The identifiability of data or information that's being used or collected in the research, the sensitivity of those data as it relates to identifiability, and then the probability and magnitude of harm as it relates to the sensitivity of the data and the overall benefits of the study to the greater good. Now, the overarching set of guiding criteria for review of any research project that comes to the IRB for review are those requirements articulated in the Code of Federal Regulations in what we call the 111 criteria. Now, I have detailed all of the 111 criteria in the chapter, and I'm not going to do that here for the purpose of this presentation. But I want to say that the 111 criteria only apply to non-exempt human research. So before the IRB begins to apply those criteria for review, there is a process for eliminating other research activity that either does not need IRB review or does not need a regulatory review. So this starts with two questions. Is it research activity that meets the definition of human research? And if it is human research, is it exempt or non-exempt? So let me start with, is it human research? This is the question that relates directly to the federal definition of human research. I'm paraphrasing, but basically the question is the research activity, the systematic collection of information, intended to produce generalizable knowledge about human behavior or the social environment? Now, assuming the systematic collection of information and the intent to produce generalizable knowledge, the most challenging part of this definition and the crux of the human research determination is the question related to, is the research about the people, or is it about a policy, a practice, a program, a company, or something else? If research activity does not meet the definition of human research, it does not need IRB review, or it does not need ongoing IRB oversight. Now, a simplistic example of not human research activity would be the secondary analysis of existing data that were collected for non-research purposes. Such could be as all kinds of data that a government might collect, such as birth or death, taxes, participation in programs, insurance costs, medical care, whatever. The government collects lots of data. These are data that are collected systematically, but are descriptive and not intended to be generalizable. However, using these data, a researcher may have a research question that is intended to produce generalizable knowledge about a program, for example. A good example would be, does participation in a wellness program reduce the cost of healthcare over time? Certainly there have to be people who are enrolled in the wellness program to determine if there's a reduced cost of healthcare over time. But this sort of research is not about the people. The question is about the impact of the wellness program on the cost of healthcare over time. This is a straightforward example of program evaluation, and program evaluation is research activity, but it's research activity that does not meet the federal definition of human research. However, what if the researcher adds by race to the question? It's still about a wellness program. However, when the researcher starts to ask the question as to who uses the wellness program and is there a differential impact of the program by race, the more likely they are beginning to cross the line into human research, where research activity is as much about the people as the program. Now, this is a very simple example, but my point is that parsing out what is human research can be nuanced and surprisingly complicated because it does depend on how the research question is framed. This question of, is it human research, is important because if it's not human research, then no IRB review is required. However, if the research activity is human research, before we get to the question of exempt or non-exempt, there's another series of questions that are contextual that the IRB has to contend with. If the project is federally funded, then the ethical principles and the federal regulations have to be applied. There's no question of that. Now, I will also note that most institutions require IRB review across projects, regardless of whether they're federally funded or not, and expect that IRB review to be consistent with the federal guidelines. But that's an institutional choice. The federal regulations are intended to be applied to federally funded research projects. The other question that IRBs will sort out is the institution engaged in human research? Now, the question of engagement and engaged in research matters because it's possible to have multiple collaborators who are consultants or who are co-authors, who are advisory in terms of methodology, but who are not involved with the design of the study or the participant-facing activities and are not engaged in human research from the IRB perspective. If a researcher is not engaged, then the institution is not engaged, and there does not need to be IRB review. So if it's a research activity that is human research, that is federally funded or not, depending on the institutional policy, and the researcher and therefore the institution are engaged, the next question relates to whether the study is exempt or non-exempt. Now, there's a table in the chapter that maps out the regulatory authority and the level of risk that's associated with exempt and non-exempt projects. Why this distinction is important for researchers and other stakeholders is that exempt does not mean exempt from IRB review, but rather that the project is exempt from the regulatory review. So it is reviewed through the lens of the ethical principles of Belmont, respect for persons, beneficence, and justice, but not through the lens of the 111 criteria. Now, the most common difference between exempt and non-exempt research is related to the level of risk of harm to participants. Minimal risk and greater than minimal risk are the two levels of risk that IRBs consider. Minimal risk is defined in the regulations as the probability and magnitude of harm or discomfort anticipated in the research are not greater in and of themselves than those ordinarily encountered in daily life. Now, anything else is considered greater than minimal risk, which is not defined in the regulations. And so it's up to the discretion of the IRB reviewers to decide whether the risk of any given research activity is minimal risk or greater than minimal risk. Now, as you can see from the definition of minimal risk, that's actually somewhat subjective. The risk of ordinary life for a homeless person or somebody who is undocumented are decidedly different than the everyday risk of somebody in middle America. Similarly, online risk is different than an in-person interview. So risk is really very project specific and considered in the context of the vulnerability of the person. Now, vulnerable populations are defined in the regulations and include children, prisoners, and other groups of people who are considered to need additional protections due to social or economic conditions. Now, most human research with vulnerable populations is likely to be considered non-exempt and subject to regulatory review, although it can depend on the purpose of the study and whether any of the information is already publicly available. Similarly, there can be minimal risk, non-exempt projects that have more sensitive data and so require a more robust data protection plan and so forth. Whatever the case, the probability and magnitude of harm are the important concepts related to the assessment of the difference between minimal risk and greater than minimal risk. For the IRB, magnitude of harm starts with what could possibly go wrong in the project and what would be the actual harm to the participant. So the probability of harm is exactly what it sounds like, given all the relevant factors related to the information collected or being used. What is the likelihood of harm? This is very project specific and related to, among other things, the vulnerability of the participants, the identifiability of the data, and the sensitivity of those data if there were to be a breach of confidentiality. Now, with all research data, immediate identifiability, direct identifiability, is one issue. but so is the likelihood of re-identification of de-identified data. And so I want to emphasize that having de-identified data is not the be-all, end-all to removing risk. It's important that data providers, data stewards, and researchers are cognizant of and realistic about the probability and magnitude of harm, and that there is a robust data protection plan in place that's commensurate with those harms. Now, Chapter 5 and 6 in this handbook talk much more at length and in depth about these issues, so I'm not going to go into that further, but just so you know that this issue of probability and magnitude of harm as it relates to data is big for the IRB. Now, the third consideration that distinguishes exempt from non-exempt studies is the issue of informed consent. Exempt projects will have a consent process that are required to meet the documentation or other requirements of consent as detailed in the regulations. I spell out in the chapter the 116 criteria for regulated consent and the 117 criteria for waiver of consent, as non-exempt projects are subject to the regulations. Now, before transitioning to some specific strategies when collaborating with the IRB, I want to talk briefly about some institutional policies that might affect the use of data as it relates to data sharing. Now, Chapter 3 in the handbook plumbs the depths of DUAs and how these contracts address ownership of the data, intellectual property rights, and so forth. So I'm not going to go into any of that. But what I want to emphasize is that it's important to know that institutions may have different policies for incoming data and outgoing data. Now, typically, because a researcher is an employee or affiliated with the institution in some way, the work product of the research belongs to the institution or the organization, not to the researcher. This is why researchers are not the people to sign the data sharing agreements. As such, it's important to know which unit in the organization processes data sharing agreements and what the sequence of events is for an IRB approval and a data use agreement approval in the same project. Some institutions will not sign a data sharing agreement until the IRB approval is completed, and for some, the IRB approval is contingent on the data sharing agreement. Now, as I indicated before, there are a myriad of ways in which existing data or combinations of administrative data may be used in, collected or used in research. And these may involve various iterations of data sharing agreements. So it's important to know when a data use agreement or a data transfer agreement is needed and when in the IRB process it needs to be executed so that neither process is held up by the other process. Now I want to transition to some strategies for communicating and collaborating with the IRB. And just kind of one introductory remark about that is that it's important to know that at any given time, IRB staff are reviewing potentially hundreds of projects from different disciplines with different funding sources with different regulatory requirements. Communicating effectively and constructively with the IRB is key to getting studies reviewed in an efficient and an effective manner. Now, some strategies for communicating with an IRB professional who's working on your project that I've found to work well include the following. Know which IRB will be the IRB of record for your project. If it's a multi-site project, it may not be your IRB, it may be another IRB. Or your IRB may be the IRB of record for all of the organizations involved. So figure out which IRB will be the IRB of record, and then use the approved protocol template to present your study to the IRB. Now, protocol templates may vary and actually will vary between IRBs in terms of format and the order of the elements. However, they are all designed to collect the information required to consider any project in light of the 111 criteria. They are also designed to help the IRB rule out those projects that don't need to go through a regulatory review. And so it's important to follow the protocol template as precisely as you can. And that includes a detailed description at a granular level of what the research is proposing to do with participants and their identifying information. Because IRBs must consider whether a project is exempt or non-exempt, it's important to focus particular attention on the specific interactions with participants or their identifying information. The IRB is less concerned about the theory that underlies the project and much more focused on assessing the risks to participants, as I've said repeatedly. This includes needing very specific detail of the how, when, why, and where interactions with participants and their identifying information will occur. It's also important to give a description of the specific roles and responsibilities of the study team members, and similarly, if the study is collaborative or multi-site, there needs to be a description of what each collaborator and site is doing on the project. The IRB also needs to know the details of the data management plan for the life cycle of the data from the point of collection to how it's being stored and ultimately what's done with it at the end of the project. It's important in the protocol to clearly spell out the identifiability and the sensitivity of the data. As I've said, the IRB will focus on the risk associated with the data, and in particular with retaining identifiers. If a study is going to keep identifiers beyond the end of the study, that's important to note. And then also the IRB will be concerned about re-identification of de-identified data and what the risks to participants might be. In that regard, an IRB will also is that any attention to whatever the output data set is for research that's combining multiple data sets, as the risks of the combined data set or the output data set may be different than the individual data sets that went into the outcome data. And then, of course, if applicable, identify the type of data sharing agreement and the process for establishing that data sharing agreement. Note that every protocol submitted to the IRB for review stands on its own merit, so communication is key. Every IRB in the United States is subject to the same ethical principles and the same regulatory requirements. Those do not change. Yet every IRB has their own way of applying the regulations. Just because one IRB found a project to be exempt does not mean that another IRB will find the same thing. Consistency within and between IRBs is a challenge, especially with complicated research. Therefore, the collaborative process with the IRB is of utmost importance. The more information the IRB has to work with, the more consistent the results of the review will be. The most important advice I can give you is to get to know your IRB, communicate with the language of the IRB, which is about protection of participants, risks and benefits, the sensitivity and identifiability of information, consent, and the probability and magnitude of harm. Thank you for your time. I want to now open this up for questions you might have in the time remaining.